water. Get rid of them island powder. When I flick the monkey man, I'm stand. Na 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 na. Watch your badness.
You're in the mix with DJ Slick.
It's serious. How Japa sleep, tell them to wake up.
You're in the mix with DJ Slick.
Breaking news, my loyal viewers and still hear a lot of people jump for joy and excited about what the former Prime Minister is saying. He's not saying that the case should stop. But what he's saying that the previous judge who was involved in the case should have stopped the case when they found out there was a lot of error. I want if you understand what I'm saying. I'm going to repeat myself so even a baby can understand. The former Prime Minister is basically saying the judge in the case made a mistake by not stopping the trial when they found out that something or some of the people on the jury might have done something wrong. That's basically what the former Prime Minister is saying.
For attorneys at law PJ Patterson and Hugh Small KC, trial judge Justice Lennox Campbell's decision to continue the murder trial of Vybz Kartel and his then co-accused in 2014, despite accusations of jury tampering, was a fatal error which made any verdict unacceptable in accordance with the tenets of justice. The joint statement, however, suggests that Justice Campbell, or the three judges of the Court of Appeal, should have been made aware of a previous ruling by the Court of Appeal in 1983, where an entire jury was discharged because one member was believed to be potentially biased. That 1983 trial was a liable case involving the Gleaner Company Limited and John Hearn versus Michael Manley. In that trial, it was revealed that the foreman of the jury was employed to the National Workers Union, NWU, while Mr. Manley was also the NWU's island supervisor. The trial judge then discharged the foreman on the grounds of apparent bias. The Court of Appeal of Jamaica decided then to discharge the entire jury and ordered a new trial. Mr. Patterson and Mr. Small believe that if this case had been brought up to guide the judges when it was revealed that a juror was bribed and attempted to bribe the rest of the jury in the Kartel murder case, the jury would have been dismissed in its entirety. In some quarters, the Privy Council's ruling is seen as an indictment on Jamaica's justice system. It's why Mr. Patterson and Mr. Small describe the entire situation as regrettable.
Mr. Palmer is not a convict. He does not have a conviction. Mr. Sean Campbell does not have a conviction. Mr. Andre St. John is not convicted on this matter. And Mr. Keras Jones, his conviction is quashed on this.
Meanwhile, it's the hope of attorney Linda Hudson that the Court of Appeal considers all the relevant factors. One that immediately comes to mind:
the time that the appellants have spent in custody and also media publicity, etc. But I'm sure, I feel comfortable that the Court of Appeal will come to the right decision on that.
And in the event there's a retrial, Ms. Hudson says there's one question at the center of it all.
And whether a fair trial is at all possible.
There were some supporters of Mr. Palmer who were unstoppable. The men said they had to be at the Privy Council on Thursday for the judgment.
I know, say, there's not the 100% to say my man guilty them way there, to how they trying to portray him. You understand? I'm not saying he's without sin, but there's a lot more to this, and them not giving no justice.
One that has evoked a sense of joy from those representing the appellants. For one, Isaac Buchanan, attorney for Adidja Vybz Kartel Palmer, is loving every minute.
I'm very happy about that. It was a just decision, it was the right decision, and it was what was expected.
And as expectations reach fever pitch among supporters, the question among many is, what does it mean for Mr. Palmer and his team? Standing outside the Privy Council, just minutes after the judgment, Mr. Buchanan gladly responded.
What it means is that in the same guidance that they had sorted, the judges have the discretion now to deal with the matter at the local level, which is in keeping with judicial independence, in keeping with our independence and what our constitution speaks about.
Julian Malin's KC, who was a part of the legal team for Sean Storm Campbell, says the Privy Council made a sound judgment.
Well, I think it was entirely the right decision. They're on remand now, not convicted persons. So we regard this as a very big win.
When you look at the evidence and how the court deal with it in Jamaica, you can see it was an unsafe conviction, and a lot of violation of rights.
I expect him to get released, you understand, because there are so many discrepancies in the case.
Nah, I lime and water, get rid of them island powder. When I flick the monkey man, I'm nah. Watch your badness.
Vybz Kartel Privy Council ruling continue. And this morning, for the first time, the DPP was responding since the judgment came down last Thursday morning. And she was asked by Tona and Ricardo about the advice she gave to the judge in the trial after it was revealed that there was an attempt to bribe the jurors.
DPP, having been told that all of your jurors in 2014 had been offered a $500,000 bribe, why did you not advise the judge that it was probably best to dismiss the jury, which was now obviously tainted?
You see, you are now trying to get me to discuss the matter, and I told you that I didn't wish to.
No, but certainly this point, DPP, is important, because here the law lords are saying you advised the judge that you were prepared to proceed even though you knew that the entire panel, 11 jurors, the forewoman told you, had been offered bribes. Wouldn't that mean in your judgment, DPP, that the entire jury, as the law lords have now found, was contaminated and should have been terminated or discharged?
Well, first of all, I am not the judge.
True, but you gave advice that you were prepared to proceed, and what I'm trying to understand.
We were prepared to proceed.
But why were you prepared to proceed with a jury that was contaminated?
No. All the other factors, that some of which I cannot go into in terms of.
So you were thinking about cost. You were thinking about how long the matter had been going.
We were also thinking of security issues. There were a lot of other issues that we cannot go into the public domain, and what our information from the foreman was, what she was saying, was that all of the attempts had to do with acquittal. Clearly, if it had been the other way, we would have, clearly, given the overriding objective of any case, which is fairness to the accused. But what would have been perhaps planted in the mind of the jurors is, okay, you need to acquit. And remember that these persons, at least two of them, are very famous. So it would have been, as far as the prosecution, when we discussed it, we would have been those ones at a great disadvantage. This is not the first time.
But with the greatest respect, DPP, that's not persuasive, because what I want you to focus on is the fact that the process now had been corrupted and contaminated, and you advised the judge that you were comfortable proceeding with a contaminated and corrupt process.
This is not the first time that I have had to deal with jury tampering.
And be that as it may, in the exercise of your judgment, why did you not see it fit to bring to an end a matter that had been corrupted?
After 64 days of trial?
Isn't the interest of protecting the impartial trial greater than the length of time that had elapsed?
I agree with you on paper, but I have done other cases where there has been jury tampering to the great negative of the prosecution. I have seen cases, I've seen jury inquiries where the juror, having been questioned, it was quite clear that it was either an accused person or an accused person's relative that approached the juror. And the juror was able to indicate to the court that it did not make any difference. He would still be able to have an impartial situation in his mind. I have had the experience. I've prosecuted many cases. And when asked, I have indicated that we don't have any problem. So in other words, we are prepared to take our chances and just try to make sure that you have a very powerful address. But this, what happened in a couple of the cases I've dealt with, didn't happen during summation. It happened before we got to summation. So I have had the experience before of jury tampering. And I have been asked before, what is my view, being the prosecutor in the matter? And even after the inquiry, it's a judgment. It's quite clear that you don't know if the juror is telling you everything about the encounter with the relative of the accused, but you are willing to take the chance nonetheless. So it has happened. I mean, both myself and Mr. Taylor, who was the prosecutor, we didn't drop from the sky. It's not the first case that we are both having to deal with. And in our experience, we have had to deal with cases where you have issues arising.
With the benefit of hindsight, do you regret the submissions you made?
You are not going to get me there. You are not going to get me.
You're in the mix with DJ Slick.
It's serious. How Japa sleep, tell them to wake up.
You're in the mix with DJ Slick.